Renters are not allowed on these paths.
Your actions caused my daughter to get hurt.
I promised my wife on her deathbed I'd protect Emma's happiness. 3 years later, I'm watching doorbell footage of Carolyn Vance dragging my 11-year-old daughter off her bike. Emma hits the pavement, hard. Her hands scrape concrete. The woman in the white SUV doesn't even look back. The timestamp says this happened 47 minutes ago while I was at work. But here's what Carolyn Vance doesn't know. I'm David Brennan, a licensed land surveyor who spends every day determining exactly what property rights actually mean. I read plat maps the way other people read novels. I know where every boundary line, easement, and right-of-way exists in this county. And I'm about to prove that everything the board president just told my daughter about trespassing is a complete lie. If you've ever watched someone abuse power they don't actually have and felt that burning need to expose them, stay right here. Because what I discovered buried in county records is about to destroy Carolyn's entire reign of terror. I'm a single father. Emma is my entire world. 3 years ago, cancer took my wife Sarah in 6 brutal months. We went from anniversary dinner to hospice in less than a season. Sarah's last words to me were simple. Keep her happy, keep her normal, promise me. I promised. Emma's grief counselor said bike riding would help. Something about movement and fresh air and not being trapped with her thoughts. So, Emma rides every day after school, through Ridgewater Hills trail system, past the duck pond, to the memorial bench where we scattered Sarah's ashes. The plaque reads, "In memory of Sarah Brennan, find joy in the journey. Hit subscribe now, because what happens next is even better." Emma stops there every single day, talks to her mom, tells her about school, about friends, about the things 11-year-olds worry about. It's the only time I see my daughter smile anymore. And Carolyn Vance, the self-appointed enforcer who drives around our neighborhood in her white SUV with custom HOA official plates, just ripped that away from her. I played the footage again, watched the board president grab Emma's handlebars, heard her screaming about renters having no trail access rights, saw my daughter try to pedal away, watched Carolyn yank harder until Emma lost balance and fell. Then, the tyrant with fake authority climbed back into her SUV and drove off. My phone was already in my hand. My neighbor had sent me the ring footage with 3 words. "You need this." I saved it to 3 different cloud services, downloaded it to my laptop, sent copies to my personal email, because I knew exactly what I was looking at. Evidence. Emma was sitting on the bathroom floor when I got home. Knees pulled to her chest, hands wrapped in gauze. The school nurse had cleaned her scrapes and called me, but I'd been in a survey meeting 2 counties away. By the time I got the message, Emma had already taken the bus home alone. "Dad," her voice was so small. She said, "I was trespassing. She said renters aren't allowed on the trails. She said if I ever rode my bike there again, she'd have me arrested." I knelt beside her. My daughter's eyes were red from crying, her hands shaking even through the bandages. "Did she hurt you anywhere else?" Emma shook her head. "Just my hands and my knee." She pulled up her jeans to show me a bruise already purpling across her kneecap. "But, Dad, I can't go to Mom's bench anymore. Carolyn said..." "Carolyn's wrong." I kept my voice steady even though rage was burning through my chest. "You didn't trespass. You have every right to use those trails." "But she's the HOA president. She makes the rules. She enforces rules. She doesn't make them." I helped Emma to her feet. And sometimes people in power lie because they think no one will check. Emma looked at me with her mother's eyes. "Are you going to check?" I already did. That was partially true. I'd pulled up the Ridgewater Hills subdivision plat on my laptop during the drive home, reviewed it at every red light. Something about Carolyn's claim felt wrong. Our HOA had never mentioned trail restrictions in the 3 years we'd lived here, never sent notices about renter limitations, never posted signs. Because the trails weren't HOA property. I'd seen enough public access easements in my career to recognize one. The trail system showed up on the original 2008 plat with specific designation markings, but I needed to verify it with county records, needed documentation that would hold up in court, because that's where this was heading. I settled Emma on the couch with her favorite blanket and a movie she'd seen 20 times. Then I opened my laptop at the kitchen table and started making calls. First, the county recorder's office. They'd be closed now, but I left a message requesting copies of all easement documents related to Ridgewater Hills, Subdivision Plat 2008 sir. 847. Second, the pediatrician. Emma needed those scrapes properly documented, photographed, put in her medical record with a clear explanation of how they happened. Third, I took my own photos. Emma's bandaged hands, the bruise on her knee, the bike lying in our garage with scratches on the handlebars where Carolyn had gripped them. Then I called the non-emergency police line and filed a report. The dispatcher took my information with practiced efficiency. Sir, for a dispute over HOA property access, you'll need to go through your HOA board first. This isn't a dispute. An adult physically assaulted my 11-year-old daughter. I have video evidence. I'm filing a battery complaint against Carolyn Vance. The dispatcher's tone changed. Is your daughter injured? Scraped hands, bruised knee, traumatized? Yes. An officer will be there within the hour to take your statement. I hung up and looked at Emma. She'd fallen asleep on the couch, exhausted from crying and fear, her small hands still wrapped in white gauze. Sarah had made me promise to keep her happy. I'd failed today. But I wasn't going to fail tomorrow. The police officer who arrived was young, maybe late 20s, with a name tag that read Deputy Martinez. He took photos of Emma's injuries, watched the doorbell footage 3 times, and wrote everything down in careful block letters. Mr. Brennan, I'm going to be honest with you. He closed his notepad. Technically, this is battery. An adult grabbed a child, caused injury. But given the HOA context, the DA might want to see if you've exhausted civil remedies first. Civil remedies? I kept my voice level. Someone assaulted my daughter. I understand. I'm writing this up as battery of a minor. But Ms. Vance will likely claim she was enforcing HOA rules, that she didn't intend harm, that it was an accident. Martinez looked uncomfortable. I've seen these HOA cases before. They get complicated. The footage is pretty clear. It is, and we'll investigate. But I'm just preparing you for how this might go. He handed me his card. Keep documenting everything. Any threats, any contact, any new incidents. Build your case. After he left, I sat at my kitchen table and pulled up the county GIS website, Geographic Information System, every surveyor's best friend. It showed property boundaries, easements, zoning, utilities, everything mapped in digital layers you could toggle on and off. I zoomed to Ridgewater Hills, selected the easements layer, and there it was, the entire trail system highlighted in bright green. Public access easement, dedicated to Clayton County in 2008 by the original developer, Ridgewater Properties LLC. Perpetual access for pedestrian and non-motorized vehicle use. Not HOA property, county property. I downloaded the map, saved it as a PDF, and started pulling every related document I could find. The original subdivision agreement, the developer's dedication deed, the county acceptance letter. A knock on my door interrupted me at 9 p.m. Miguel Santos stood on my porch, hands shoved deep in his jacket pockets. My neighbor from 3 streets over, HOA board secretary. I'd seen him at board meetings, always sitting beside Carolyn, nodding along with whatever she said. David, He glanced back toward the street like he was afraid someone might see him. I heard what happened to Emma. I'm so sorry. I didn't invite him in. Didn't want HOA board members anywhere near my daughter right now. Miguel seemed to understand. He stayed on the porch, shifting his weight from foot to foot. My daughter Teresa is friends with Emma. She called me crying after school. Said Emma told her what Carolyn did. Your point? My point is... Miguel pulled his hands from his pockets, and I saw they were shaking. Carolyn's out of control. She's been getting worse for 2 years now, making up rules that aren't in our CC&Rs, targeting renters specifically. I've tried to push back in meetings, but she shuts me down. Says I don't understand how to maintain property values. You're the board. Secretary, can't you... She threatens people, David. Miguel's voice dropped to barely above a whisper. My landscaping business? 60% of my clients live in this neighborhood. Carolyn's made it very clear that if I don't support her decisions, she'll tell everyone I do substandard work. She'll tank my business. I stared at him. So, you just go along with it. I have 3 kids. Teresa's going to college next year. I can't... He stopped, took a breath. But dragging a child off her bike? That's too far. Way too far. He met my eyes. If you're planning to fight this, I'll help you. I'll testify about what she's really like, about the rules she's invented, about everything. Why should I trust you? Miguel pulled out his phone, opened his email, and showed me the screen. Messages from Carolyn, dozens of them, ordering him to support her positions, threatening to make life difficult for residents who questioned her authority, telling him to back up her claims about renter restrictions, even though the actual bylaws are vague on the issue. Because I'm tired of being afraid, Miguel said, and because what she did to Emma is exactly what I've been terrified she'd eventually do. Hurt someone. I looked at this man who'd sat silently through who knows how many board meetings while Carolyn Vance built her little dictatorship. Part of me wanted to slam the door in his face, but I needed allies. Come inside, I said. Miguel sat at my kitchen table and told me everything. How Carolyn had lost her paralegal license in 2016 for falsifying documents in a real estate dispute. How she'd moved to Ridgewater Hills right after and immediately ran for the HOA board, winning because most people didn't bother voting. How she'd spent 8 years consolidating power, replacing board members with friends and family who'd rubber stamp her decisions. The treasurer is her cousin, Miguel said. The architectural review chair is her book club friend. I'm the only one left who remembers what this HOA was like before she took over. What was it like? Normal. We met 4 times a year, approved the budget, hired lawn service, planned the neighborhood picnic. That was it. He rubbed his face with both hands. Now we meet twice a month, and every meeting is Carolyn reading violation reports. Who hasn't edged their lawn properly? Whose mailbox is the wrong shade of black? Who parked facing the wrong direction? And the trail restrictions? Miguel shook his head. That's new, started about 6 months ago. Carolyn announced at a board meeting that we needed to address the renter problem. Said property values were declining because renters don't maintain standards. She proposed a 2-tier membership system. Owners get full amenity access, renters get limited access. That's probably illegal. I said that. She said I wasn't a lawyer and needed to trust her expertise. Miguel's voice was bitter. She claimed she'd researched HOA law and found precedent for amenity restrictions based on ownership status. I asked to see the research. She said it was in her files and she'd share it later. She never did. Did the board vote on this? She called it a policy clarification instead of a rule change. Said it didn't require a vote because the authority was already in our CC&Rs under the section about the board having discretion over common areas. He met my eyes. I read our CC&Rs cover to cover after that meeting. There's nothing in there about renter restrictions. Nothing. I pulled up the documents I'd downloaded earlier. The trails aren't even HOA property. Look. Miguel leaned forward, studying the easement map. His expression shifted from confusion to shock to anger as he processed what he was seeing. This is a public easement, dedicated to the county in 2008. The HOA doesn't own it, can't control access to it. Carolyn's been enforcing rules she has absolutely no authority to enforce. Does she know this? I pulled up another document. A 2019 email thread between Carolyn and the county parks department. The county had sent her a notice about trail maintenance responsibilities and included a reminder that the trails were public access easements, not private HOA property, and that access cannot be restricted except for safety reasons during maintenance periods. Carolyn had responded, "Understood. We'll maintain proper public access." Then she'd turned around and started telling residents, specifically renters, they weren't allowed to use the trails. Miguel stared at the screen. She knew the whole time, and she lied anyway. Not just lied, collected fines. I showed him another document I'd found, the HOA's 2023 annual report. Under additional revenue, there was a line item. Trail access compliance fees, $8,400. What the hell are trail access compliance fees? Fines she charged people for using trails they have every legal right to use. I pulled up my own HOA statement. Sure enough, 3 months ago, there was a $200 charge labeled Trail Access Violation, rental tenant. I'd paid it without thinking twice because I was dealing with Emma's school schedule and grief counseling appointments and didn't have energy to fight over $200. How many other renters had done the same thing? Miguel was shaking his head slowly. This is fraud. She's been collecting money based on authority she doesn't have for violations that don't exist. Yes. And she physically assaulted your daughter to enforce these fake rules. Yes. Miguel stood up, paced to my kitchen window, stared out at the dark neighborhood. What are you going to do? I looked at the documents spread across my table. Evidence of corruption, fraud, abuse of power. Everything a land surveyor knows how to find when someone tries to claim authority over property they don't control. I'm going to take her down, I said, legally, completely, and I'm going to make sure she never has power over another family again. Miguel turned back to me. Tell me how to help. Monday morning, I took a personal day from work, told my boss I had a family emergency, which wasn't remotely a lie. Emma was still too shaken to go to school. She'd had nightmares all weekend about Carolyn finding her, about police, about being arrested for riding her bike. My 11-year-old daughter was terrified of an HOA president. I dropped Emma at my sister's house across town, where she could spend the day with her cousins, then drove straight to the Clayton County Recorder's office. The clerk at the front desk was a woman in her 60s with reading glasses on a chain. How can I help you? I need certified copies of all easement documents related to Ridgewater Hills subdivision, plat number 2008-08407, specifically the trail system dedication. She typed into her computer. That'll be about 40 pages of documents, $15 for certified copies. Perfect. While she pulled the files, I wandered over to the public access computers and logged into the county's property records database. Started searching for every document related to Ridgewater Hills HOA, the original incorporation papers, the CC&Rs, every amendment filed since 2008. I found something interesting immediately. The HOA had filed an amendment in 2020, standard stuff about updating board election procedures. But buried in the middle was a new section. The board shall have sole discretion over access to and use of all common areas, including but not limited to trails, pools, and recreational facilities. Carolyn's amendment, her attempt to give herself authority over the trails. But here's the thing about public easements. You can't override them with HOA rules. Once property is dedicated to the county as a public right-of-way, it stays public. The HOA can't restrict access any more than they could close a public street that runs through the neighborhood. The clerk returned with a thick envelope of certified documents. Here you go. 43 pages total. I paid, thanked her, and sat in my car reading every single page. The original dedication deed was crystal clear. Grantor hereby dedicates to Clayton County, Georgia, in perpetuity, the following described property for use as public pedestrian and bicycle trails, to be maintained by Ridgewater Hills Homeowners Association, but accessible to all members of the public without restriction. Without restriction. I photographed every page, uploaded them to my cloud storage, then drove to the county parks department. The woman at the front desk directed me to James Holloway, the county's trail coordinator. He was younger than I expected, maybe mid-30s, with the lean build of someone who actually used the trails he managed. Mr. Brennan, right? I got your email this morning. He gestured to a chair. You said this was about Ridgewater Hills easement? I showed him the doorbell footage, watched his expression shift from curious to horrified. She dragged a child off her bike, my daughter, 11 years old, and she did it while claiming my daughter was trespassing on private HOA property. I pulled out the certified easement documents. Except, the trails aren't HOA property, they're county property, public access. Holloway took the documents, scanned through them, then turned to his computer. Hold on. He pulled up a file. We actually corresponded with Ms. Vance about this in 2019. We sent a reminder that the trails are public easements after she contacted us about maintenance schedules. I saw that email. She acknowledged understanding that access couldn't be restricted. Then she turned around and he gestured at the video still frozen on his screen, showing Carolyn's hands gripping Emma's handlebars. This is a major problem, not just for your daughter, for the county. If she's been restricting public access to a county easement, that's a violation of the dedication agreement. She's also been collecting fines, called them trail access compliance fees, made almost $10,000 last year alone. Holloway's jaw tightened. That's fraud. She's charging people to use public property. He picked up his phone. I need to loop in our county attorney. This requires immediate action. What kind of action? At minimum, a cease and desist letter to the HOA, probably a formal investigation. If she's been systematically excluding people from public property and profiting from it, he shook his head. That's serious, could be criminal. I felt something loosen in my chest. Validation. Authority higher than an HOA president taking this seriously. There's something else, I said. She's specifically been targeting renters, telling them they don't have trail access rights. That's discrimination based on ownership status. On public property. Holloway was already typing notes. Yeah, that's not going to fly, at all. He printed out a form and slid it across the desk. File a formal complaint with the county. Document everything. The assault, the false claims, the illegal fees. We'll open an investigation, and I guarantee the county attorney will want to pursue this. I filled out the form right there. Every detail, every document, every lie Carolyn Vance had told while building her little kingdom on the property she never controlled. When I finished, Holloway made a copy and handed me back the original. We'll be in touch within 48 hours. And, Mr. Brennan, your daughter has every right to use those trails. If Ms. Vance tries to stop her again, call the sheriff. Immediately. I drove home with a folder full of certified documents and the first real hope I'd felt since watching that doorbell footage. Carolyn Vance had built her power on lies. And lies don't hold up against survey maps. Emma's panic attack happened Tuesday afternoon. My sister called from the ER, voice tight with controlled fear. She started hyperventilating at lunch, said her chest hurt. She kept saying someone was going to arrest her. I broke every speed limit getting to the hospital. They had Emma in a curtained exam bay, oxygen monitor on her finger, my sister holding her hand. My daughter looked so small in that hospital bed, eyes red and swollen, breathing still too fast. Dad, she started crying the moment she saw me. I'm sorry, I just couldn't breathe. Shh, it's okay, you're okay. I pulled her into my arms, felt her whole body shaking. Nobody's arresting you, nobody's taking you anywhere. The doctor, Dr. Patel according to her badge, stepped around the curtain. Mr. Brennan, can we talk outside? I kissed Emma's forehead and followed the doctor into the hallway. Your daughter had an acute anxiety attack, Dr. Patel said. Her sister explained about the incident with the HOA president. Emma's convinced she's going to be arrested for riding her bike. That's not going to happen. I know that. You know that. But Emma is 11 and traumatized. She witnessed her mother's death. She's dealing with complicated grief, and now an authority figure has physically assaulted her while making threats about police and arrest. Dr. Patel's expression was hard. This is serious psychological harm, Mr. Brennan. Emma needs to feel safe again, and she needs to know that the person who hurt her will face consequences. She will. How? Because from Emma's perspective, this woman is powerful and untouchable. Kids understand power dynamics very clearly. Right now, Emma believes the HOA president can hurt her whenever she wants. I thought about the documents in my car. The county investigation already underway. The attorney I'd hired that morning, Jessica Chen, who specialized in HOA abuse cases and had won 3 major settlements against overreaching boards. The woman who hurt Emma has been breaking the law, I said. She's been restricting access to public property, collecting illegal fines, and using authority she doesn't actually have. I'm in the process of exposing all of it. Dr. Patel studied my face. You're going after her. Legally, thoroughly, yes. She nodded slowly. Good, because I'm documenting this panic attack as directly related to assault and ongoing psychological trauma. If you need medical testimony about the harm this woman has caused your daughter, I'll provide it. I stayed with Emma for 3 hours, held her while she cried, promised her over and over that she was safe, that Carolyn Vance couldn't hurt her anymore, that Daddy was handling it. By the time we got home, it was dark. I tucked Emma into bed, set up the baby monitor I hadn't used in years, just so she'd know I could hear if she needed me, and went back downstairs to my laptop. An email from Jessica Chen, the attorney, was waiting. David, reviewed all documents you sent. This is an exceptionally strong case. The doorbell footage alone is solid battery. The easement fraud adds civil liability. The targeting of renters potentially opens Fair Housing Act violations. I recommend we file both criminal complaint and civil suit. We should also notify the County Bar Association about her prior disbarment. She's likely engaged in unauthorized practice of law by claiming legal expertise she doesn't have. We'll have paperwork ready by Thursday. JC. Another email from James Holloway at the county. Mr. Brennan, county attorney, reviewed your complaint. We're issuing cease and desist to Ridgewater Hills HOA, effective immediately regarding any trail access restrictions. We're also demanding return of all trail access fees collected since 2019 and conducting audit of HOA financial records. Letter being sent certified mail tomorrow. Investigation ongoing. Thank you for bringing this to our attention. This is exactly the kind of easement abuse we need to shut down. JH. I sat back in my chair, reading both emails twice. This was happening, really happening. My phone buzzed. Miguel, Carolyn just called emergency board meeting for tomorrow night. She's saying you've been harassing her and making false claims. She wants to discuss taking legal action against disruptive residents. I think she's going to try to fine you or start eviction proceedings against your landlord, I typed back. Let her try. I'll be there. Miguel's response came immediately. I'm voting against her. Whatever she proposes. Just FYI. I looked at the clock. 9:47 p.m. Emma was finally sleeping upstairs, sedated with exhaustion and anxiety medication. My daughter shouldn't be on anxiety medication because of an HOA president. My wife had made me promise to keep Emma happy, to keep her life normal. I'd spent 3 years trying to honor that promise while navigating grief and single parenthood and the impossible task of being both mother and father to a child who'd lost half her world. And then, Carolyn Vance had grabbed my daughter's bike and yanked her to the ground and threatened her with arrest. Over trails she had no authority to control, over rules that didn't exist, over power she'd invented. I opened my laptop and started preparing for tomorrow's board meeting, printed copies of every easement document, every email from the county, every receipt showing illegal fees, Dr. Patel's medical documentation of Emma's panic attack. Carolyn Vance wanted to discuss taking legal action? Perfect. So did I. The emergency board meeting was scheduled for 7 p.m. Wednesday in the clubhouse. I arrived at 6:45 with a leather folder containing every document I'd gathered and a small audio recorder I'd tested 3 times to make sure it worked. Georgia is a one-party consent state. I could legally record any conversation I participated in. Miguel was already there, setting up chairs. He glanced at me, gave a tiny nod, then went back to arranging the room. We'd agreed he wouldn't acknowledge me beyond basic courtesy. Couldn't tip Carolyn off that he was helping. Other board members filtered in. Linda Vance, Carolyn's cousin, the treasurer, barely looked at me. Sharon. Hartley, the architectural review chair, gave me a tight smile that didn't reach her eyes. Carolyn arrived at exactly 7 p.m. in a navy blazer and her usual expression of condescending authority. She set her bag down at the head table, pulled out her agenda, and only then acknowledged my presence. Mr. Brennan, you weren't invited to this meeting. It's an HOA board meeting. As a resident, I have the right to attend. I sat in the front row. I'm here to observe. This is an emergency executive session. Residents may only attend by specific invitation when matters concern them directly. Pretty sure matters concern me directly since Miguel said you're discussing taking legal action against me. Carolyn's jaw tightened. Miguel, why don't you explain to Mr. Brennan the difference between open meetings and executive sessions? Miguel cleared his throat. He looked nervous, but his voice was steady. Actually, Carolyn, I checked our bylaws before I came. Executive sessions are only for personnel matters, legal strategy discussions with our attorney, or contract negotiations. This meeting is about resident discipline, which requires an open meeting with the resident present. The self-appointed enforcer stared at him. Excuse me? Article 7, Section 3 of our bylaws. Miguel pulled out his copy, marked with sticky notes. Any board action affecting a resident's access to amenities or imposing fines requires notice to the resident and opportunity to be heard. David has the right to be here. I watched Carolyn's face cycle through emotions. Surprise that Miguel was contradicting her. Anger that he'd actually checked the bylaws. Calculation about how to regain control. Fine. She sat down hard. Let's proceed then. This emergency meeting concerns the disruptive and harassing behavior of David Brennan, resident of 428 Maple Drive. Mr. Brennan has been spreading false information about HOA trail access policies, has filed frivolous complaints with county offices, and has made defamatory statements about the board president. What false information? I asked calmly. You've been telling residents that the HOA has no authority over the trail system. That's categorically untrue. The trails are HOA common property subject to board regulation. I opened my folder. Actually, the trails are public access easements dedicated to Clayton County in 2008. I have certified copies of the dedication deed right here. I passed documents to each board member, watched their faces as they read. This is, Linda started, a public easement, I finished, which means the HOA has no authority to restrict access. The trails belong to the county. We maintain them, but we can't control who uses them. Carolyn snatched the document from Linda's hands, scanned it. Her face went pale. Where did you get this? County Recorder's Office. Public records. Anyone can access them. I pulled out another document. I also have the email exchange between you and the county. Parks Department from 2019, where they explicitly told you the trails are public property and access cannot be restricted. That's taken out of context. Is it? I passed around copies of the full email thread. Because it looks like they told you very clearly that the trails are public access, and you responded that you understood. Then you spent the next 4 years telling renters they couldn't use the trails and collecting fines from them. The room had gone very quiet. Miguel spoke up. Carolyn, did you know these were public easements when you proposed the trail access restrictions? I was operating based on the board's authority over common areas. Common areas we own, Miguel interrupted, not public property. Sharon Hartley was reading the documents with increasing alarm. How much have we collected in trail access fees? I pulled out the HOA financial report. According to last year's annual statement, $8,400. Over 4 years? Probably close to $30,000. That we have to return, Linda said quietly. We collected fees for something we had no authority to charge for. That's not... Carolyn stood abruptly. This is premature. We need to consult our attorney before making any decisions. I already consulted mine, I said. She says this is fraud. The county attorney agrees. In fact, the county is issuing a cease and desist tomorrow, demanding you stop all trail access restrictions and return every penny you've collected. Carolyn's face had gone from pale to red. You went to the county, behind the board's back? I went to the county because you physically assaulted my 11-year-old daughter while enforcing rules you knew you had no authority to enforce. I kept my voice level. I have doorbell footage of you dragging Emma off her bike. I have medical documentation of her injuries. I have a police report for battery of a minor. And I have evidence that you've been systematically defrauding residents for years. Miguel was staring at Carolyn. You knew? You knew these were public easements and you restricted access anyway. I was trying to maintain property values by lying to residents and collecting illegal fees. Miguel's voice rose. Carolyn, you've exposed this HOA to massive liability. If every person you charge files suit, they won't, Carolyn snapped. Most of them are renters. They'll just move. Like, that makes it okay? Miguel stood up. You assaulted a child, Carolyn. A child. The board president grabbed her bag. This meeting is over. I'm calling our attorney. Sit down, Miguel said. I'm calling a vote right now. Motion to immediately suspend Carolyn Vance from the board pending investigation into her conduct and the HOA's legal exposure from the trail access issue. You can't... Second, Sharon said quietly. Carolyn stared at her friend. Sharon, you told me renters were causing problems. You didn't say you were restricting access to public property. You didn't say you were collecting money we had no right to collect. Sharon wouldn't meet Carolyn's eyes. I have to protect this HOA. Motion to suspend. Seconded. All in favor? Miguel's hand went up immediately. Then Sharon's. Then, after a long pause, Linda's. 3-1. The motion passes, Miguel said. Carolyn, you're suspended from the board effective immediately. Please surrender any HOA property, documents, and access credentials by Friday. The woman in the white SUV stood frozen for a long moment. Then she grabbed her bag and walked out without another word. The door slammed behind her. Miguel sank back into his chair, hands shaking again. Oh my God. You did the right thing, I said. I just ended an 11-year friendship. She ended it when she started breaking the law. The meeting dissolved into chaos after that. Linda pulling financial records to figure out how much they owed in refunds. Sharon making lists of residents who'd been charged trail fees. Miguel just sitting there looking shell-shocked. I left them to sort it out and drove home to check on Emma. She was asleep on the couch, her bike propped against the wall next to her like a security blanket. I sat down beside her and sent a text to my attorney. Board suspended Carolyn tonight. 3 votes to 1, county cease and desist coming tomorrow. What's next? Jessica's response came within minutes. Now, we file civil suit for battery, fraud, and IIED. And we make sure she never has power over anyone again. I'll have papers ready by Monday. I looked at my daughter sleeping peacefully for the first time in days. We're winning, I whispered to her, just like Mom would have wanted. Thursday morning, the county's cease and desist letter arrived via certified mail to every board member and was simultaneously posted on the HOA's official website. I knew because Miguel texted me a photo at 8:47 a.m. The letter was 3 pages of dense legal language that boiled down to stop restricting trail access immediately, return all illegally collected fees within 30 days, and submit to a full audit of HOA finances related to the easement property. By 10 a.m., my phone started buzzing with calls from neighbors. David, did you see the county letter? Is it true Carolyn's been charging us for fake violations? Can we get our money back? I answered every call the same way. Contact the HOA board, review your payment history, document any trail fees you paid, and file for refund. By noon, Miguel called. We've gotten 47 refund requests. This is going to bankrupt the HOA. How much are we talking? At least 30,000, maybe more. We have reserves, but not enough to cover this and still operate. He sounded exhausted. Linda's having a breakdown. She's the treasurer. She signed off on all those financial reports showing trail fee income. She's terrified she'll be personally liable. Was she aware they were illegal fees? I don't think so. Carolyn told us it was compliance revenue for amenity access. We didn't question it. Miguel paused. We should have questioned it. We're all culpable for not doing our jobs properly. The difference is intent, I said. Carolyn knew she was lying. The rest of you were negligent, but not criminal. My attorney might disagree. You've lawyered up? All of us have. Sharon, Linda, me. We need to protect ourselves. His voice dropped. David, I'm sorry for all of it. I knew Carolyn was out of control, and I stayed quiet because I was afraid. If I'd spoken up 2 years ago, Emma would never have been hurt. I thought about that. About how many small decisions by good people staying silent can enable one bad person to cause massive harm. You spoke up when it mattered, I said finally. That counts for something. After I hung up, I opened my laptop and started organizing my evidence for the lawsuit. Jessica had sent over the complaint draft, 32 pages detailing counts of battery, assault, fraud, intentional infliction of emotional distress, and civil rights violations. The damages section requested compensation for Emma's medical expenses, therapy costs, pain and suffering, and punitive damages, sufficient to deter similar conduct and send a message that abuse of HOA authority will not be tolerated. Jessica had attached a note. The punitive damages are where we hit hard. Georgia law allows up to 3 times compensatory damages for willful fraud. We can push for 6 figures here. Carolyn needs to feel this. I printed the complaint, read through it twice, signed it, and scanned it back. My phone rang. Unknown number. Mr. Brennan, this is Karen Walsh from Channel 7 News. I received a tip about an HOA president assaulting a child over bicycle trail access. Is this something you'd be willing to discuss on camera? I sat back in my chair. Media attention, public exposure. Who gave you the tip? I'm not able to reveal sources, but I've seen some of the documentation. The doorbell footage, the county cease and desist letter. This is a story our viewers care about. HOA overreach, child safety, public access rights. I thought about Emma, about putting her trauma on the news. My daughter's been through enough. I won't put her on camera. Understood. But would you be willing to speak about what happened? We can keep Emma's identity protected. No footage of her, no full name. What's your angle? The truth. An HOA president with no legal authority restricts access to public trails, charges illegal fees, then physically assaults a child who dares to use the trails anyway. That's news. Karen's voice was direct, professional. And between you and me, I grew up in an HOA that made my parents' lives miserable. I have personal interest in exposing abuse of power. I made my decision. I'll talk to you, but Emma stays anonymous. Deal. Can you meet me at the trail location tomorrow morning? We'll shoot some footage of the public easement, get your statement, and I'll try to get comment from Miss Vance. Good luck with that, Karen laughed. We have ways of finding people who don't want to be found. Friday morning, I met Karen Walsh and her cameraman at the trailhead. She was in her 40s, dressed in a blazer despite the heat, with the kind of direct eye contact that said she'd interviewed hundreds of people and wouldn't be bullied or charmed. We walked the trail while she asked questions. I showed her the memorial bench, explained about Sarah, about Emma's grief therapy, about why the trails mattered so much. And Carolyn Vance told your daughter she was trespassing? Karen asked. Dragged her off her bike while screaming about renters having no access rights to private HOA property. Except it's not HOA property. Correct, it's public county easement, always has been. Karen's cameraman filmed the trail system, the easement markers, the memorial bench. Karen did a stand-up segment explaining the legal situation, then turned back to me. What do you want people to understand about this? I thought about Emma's panic attack, about Sarah's final request, about Miguel's fear, and all the other residents who'd stayed quiet while Carolyn built her petty empire. HOA boards have real power over people's lives, I said. But that power isn't unlimited. When board members start inventing rules and threatening residents and collecting money for violations that don't exist, that's not governance. That's extortion, and it needs to be stopped. What would you say to other homeowners dealing with similar situations? Document everything, know your rights, and don't be afraid to push back. People like Carolyn Vance rely on fear and intimidation. They count on residents not checking their claims, not questioning their authority. I looked directly at the camera. But when you actually verify what power they have versus what power they claim to have, bullies fall apart fast. Karen smiled. That's a great quote. We're airing this Sunday evening news. I'll send you a link when it goes live. Sunday evening, my phone exploded. The news segment was 7 minutes long. Karen had done her homework, interviewed the county attorney about easement law, gotten comment from a professor at Georgia State who specialized in HOA regulations, and ambushed Carolyn outside her house for a statement. Carolyn's on-camera response was defensive and aggressive. I have every right to protect my neighborhood from disruptive influences. Mr. Brennan has consistently violated HOA policies. But the trails aren't HOA property, Karen interrupted. According to county records, I'm not discussing ongoing legal matters, Carolyn snapped, then retreated into her house. The segment ended with Karen summarizing. The Ridgewater Hills HOA has agreed to refund all trail access fees and is now under county audit. Carolyn Vance has been suspended from the board and faces potential criminal charges for battery of a minor. This case raises important questions about HOA, authority and accountability across Georgia. My phone showed 63 text messages, 24 missed calls, and an email inbox that had exploded with messages from other HOA members, news reporters, and people I hadn't talked to in years. Miguel texted, "We're getting calls from other neighborhoods. Turns out Carolyn did consulting for 3 other HOAs in the county. They all want to know if she screwed them over too." Jessica Chen emailed, "News coverage is perfect for our case. Establishes pattern of behavior and shows community impact. Also, the publicity will make it very hard for Carolyn to claim this was all a misunderstanding." Court date set for March 15th. Discovery starts next week. I showed Emma the news segment, the edited version that didn't show her face or mention her name. She watched silently, curled up next to me on the couch. When it ended, she asked, "Is Carolyn going to go to jail?" "Maybe, probably not for long, but she'll face consequences." "Good." Emma was quiet for a moment. "Can I ride my bike tomorrow?" I felt something break open in my chest, relief, hope. "Yes, sweetheart. You can ride your bike anywhere you want. The trails are yours. They always were. Discovery in a civil lawsuit is a beautiful thing, especially when the defendant has been systematically breaking the law for years and is too arrogant to cover her tracks properly. Jessica Chen filed our complaint on February 3rd. By February 10th, we'd served subpoenas for all HOA financial records, all of Carolyn's emails and text messages related to trail access policies, all board meeting minutes since 2019, and depositions from every board member. Carolyn's attorney, a man named Robert Klein, who specialized in HOA defense, tried to fight the discovery requests, claimed they were overly broad, harassing, intended to embarrass his client. Judge Patricia Morrison wasn't having it. Mr. Klein, your client is accused of fraud, battery, and civil rights violations. The plaintiff is entitled to full discovery of records related to those allegations. Motion to limit discovery is denied. Your client has 20 days to comply. We received 14 boxes of documents. I spent 3 days at Jessica's office going through everything with her paralegal, a meticulous woman named Sandra who'd worked HOA cases for 15 years and knew exactly what to look for. "Oh, this is good," Sandra said on day 2, holding up an email thread. "Carolyn to the board, March 2021. We need to do something about the renter problem. They're bringing down property values and don't respect community standards. I propose we restrict their access to amenities as much as legally possible." She put it in writing, I said. "They always do. Bullies love documentation. Makes them feel official." Sandra added it to the evidence pile. Here's another one. June 2021, Carolyn to Linda Vance. "The county says we can't restrict trail access because of the easement, but they don't have enforcement. Resources. If we just implement the policy and collect fees quietly, no one will check." I read over her shoulder. There it was, Carolyn admitting she knew the restrictions were illegal and planning to enforce them anyway because she thought she'd get away with it. "This is conspiracy to commit fraud," Jessica said, reading the same email. "She's admitting knowledge of illegality and intent to proceed anyway. This is exactly what we need for punitive damages." We found more. Emails to Sharon Hartley about targeting rental properties for aggressive enforcement. Text messages to Linda about making examples of residents who challenge board authority. Board meeting minutes where Carolyn shut down questions about the legal basis for trail restrictions. And we found something else, something bigger. A contract between Ridgewater Hills HOA and Community Standards Consulting LLC for $45,000 over 3 years. Services described as policy development and enforcement training. "Who owns Community Standards Consulting?" I asked. Sandra pulled up Georgia's corporate registry. Filed 2020, registered agent is Carolyn Vance. We all looked at each other. "She created a fake consulting company," Jessica said slowly, "and paid herself $45,000 in HOA money for non-existent services." "That's embezzlement," I said. "That's embezzlement," Jessica confirmed. "Sandra, flag this for the DA's office and pull every payment made to this company. I want documentation of every fraudulent invoice." By day 3 of document review, we'd identified $73,000 in questionable payments from HOA funds to companies owned by Carolyn or her family members, the consulting company, maintenance services from her nephew's lawn care business at rates double the market, legal research fees to a paralegal firm she co-owned before losing her license. "She's been looting this HOA for years," Sandra said. The deposition started in March, Linda Vance first, looking exhausted and terrified, admitting she'd signed off on financial reports without actually reviewing them. "Carolyn told me what to approve. I trusted her." Sharon Hartley next, breaking down in tears when Jessica showed her the emails about targeting renters. "I didn't know she was making up the rules. I thought we were just enforcing the CC&Rs. Miguel Santos, steady and clear, testifying about every time he'd questioned Carolyn's authority and been shut down or threatened. She said if I didn't support her decisions, she'd destroy my business. I believed her. I'd watched her destroy other people. Then Carolyn's deposition. Jessica and I sat in the conference room at Robert Klein's office while Carolyn took her oath to tell the truth. She looked smaller than I remembered, older. The white SUV confidence was gone. Jessica started gentle. Background questions, how long she'd been president, what her responsibilities were. Then, "Ms. Vance, did you receive training on HOA governance when you joined the board?" I had extensive experience from my paralegal career. "The paralegal career that ended when you lost your license for falsifying documents?" Robert Klein objected. "Relevance? Goes to credibility and pattern of dishonest conduct," Jessica said smoothly. I'll rephrase. Ms. Vance, you received training on property law during your paralegal career, correct? Yes. Including easement law? A pause. Some. So you understood what a public access easement is? Generally. Jessica slid across a document. This is the county's 2019 email to you, explaining that the Ridgewater Hills Trail System is a public easement. Do you remember receiving this? Carolyn barely glanced at it. Yes. And you understood that public easements cannot be restricted except for safety reasons? The email says that, yes. But you proceeded to restrict trail access anyway. Why? The board has discretion over common areas. Public easements aren't common areas. They're public property. Jessica's voice stayed calm. You knew that, correct? Silence. Ms. Vance, you're under oath. I believed we had authority to regulate usage even if we didn't own the property. Based on what legal precedent? My research. What research? Can you cite a single case supporting HOA authority to restrict public easement access? Carolyn's attorney jumped in. You don't have to answer that. But Carolyn was already floundering. I consulted with attorneys. Which attorneys? Jessica leaned forward. Give me names and dates of consultations. I don't have that information with me. Because those consultations never happened, did they? Jessica slid across another document. This is an email from you to the board saying you'd researched HOA law and found precedent for amenity restrictions. But you never actually did that research, did you? I don't recall. You made it up. You told the board you had legal authority you knew you didn't have. You enforced fake rules. You collected $30,000 in illegal fees. And when my client's daughter used the trail she had every right to use, you physically assaulted her. That was an accident. An accident? Jessica played the doorbell footage on her laptop, turned the screen toward Carolyn. Walk me through how accidentally you grabbed Emma Brennan's handlebars and dragged her off her bike. I watched Carolyn watch the video, watched her see herself through other eyes. Aggressive, threatening, violent. I was trying to stop her from trespassing on public property where she had every legal right to be, which you knew because the county told you explicitly. Jessica paused. You assaulted an 11-year-old child to enforce authority you invented. Carolyn's face crumpled. I was trying to protect property values. By breaking the law? I thought, if I just maintained standards, if people saw the HOA had strong leadership. She looked lost. I built that neighborhood into something valuable. You built a dictatorship, Jessica said quietly. And you hurt a child. The deposition continued for another 2 hours, but that was the moment I knew we'd won. Carolyn Vance wasn't a villain. She was a small person who'd been given a little power and let it consume her until she couldn't tell the difference between leadership and tyranny. And now she was going to pay for it. The criminal trial came first. Simple battery, misdemeanor charge. The DA offered Carolyn a plea deal, admit guilt, 6 months probation, anger management classes, and permanent ban from serving on any HOA board in Georgia. Carolyn refused, insisted on going to trial. Her attorney must have advised against it. But I'd seen her deposition, seen how she couldn't accept that she'd done anything wrong. She genuinely believed she'd been protecting her neighborhood, and that Emma was the one who'd been in the wrong. The trial was set for April 15th. Clayton County Courthouse, Judge Raymond Cooper presiding. Emma didn't have to testify. She was a minor, and we had the video evidence. But Dr. Patel did. Testified about Emma's panic attack, about the ongoing anxiety and nightmares, about how the assault had compounded Emma's existing grief trauma. This child watched her mother die, Dr. Patel said from the witness stand. She's been in grief counseling for 3 years, learning to cope with loss and find joy again. Bike riding was her primary coping mechanism. Ms. Vance didn't just physically hurt Emma, she destroyed the one activity that was helping her heal. The doorbell footage played on a large screen in the courtroom. Every juror watched Carolyn grab Emma's handlebars, watched my daughter try to pedal away, watched her hit the pavement, watched Carolyn walk back to her SUV without checking if Emma was okay. The defense tried to argue accident, tried to suggest Emma had been disrespectful or disobedient, tried to paint Carolyn as a dedicated volunteer, just trying to enforce community standards. Then the prosecution put on the county trail coordinator. showed the emails where the county had explicitly told Carolyn the trails were public property, showed her response acknowledging she understood. So Ms. Vance knew she had no authority to restrict trail access? The prosecutor asked. Absolutely, we made it very clear. Yet she told Emma Brennan she was trespassing on private HOA property? That was factually false. Either Ms. Vance didn't understand easement law, which seems unlikely given her paralegal background, or she was deliberately lying. The jury deliberated for 45 minutes. Guilty. Judge Cooper scheduled sentencing for 2 weeks later. Carolyn left the courthouse without looking at me. The civil trial started May the 1st. Same courthouse, different courtroom. Judge Patricia Morrison presiding. Jessica had refined our case down to the strongest claims: battery, fraud, intentional infliction of emotional distress, and violation of Emma's civil rights to access public property. The fraud count was key. Georgia's fraud statute allows treble damages, 3 times the actual loss, for willful fraud. We'd documented $30,000 in illegal trail fees, plus $45,000 in embezzled consulting fees, plus $73,000 in total fraudulent payments. Jessica was asking for $444,000 in compensatory damages plus punitive damages, sufficient to deter similar conduct. Carolyn's attorney tried to settle, offered $50,000 to make it go away. Jessica countered with $400,000. They refused, so we went to trial. Miguel testified about the board's dysfunction, about Carolyn's threats, about how she'd silenced dissent through intimidation. Sharon Hartley cried again, apologizing to me directly from the witness stand. I should have questioned her. I should have checked. I'm so sorry about Emma. The financial expert Jessica hired walked the jury through every fraudulent payment, showed how Carolyn had created fake invoices, forged approval signatures, and funneled HOA money into accounts she controlled. This wasn't poor bookkeeping, the expert testified. This was systematic embezzlement designed to look legitimate. I testified about Emma, about Sarah's death and Emma's grief and the promise I'd made, about coming home to find my daughter having a panic attack because an HOA president had convinced her she was a criminal for riding her bike. My daughter lost her mother, I said. She didn't deserve to lose her peace too. The defense tried to argue that Carolyn had acted in good faith, that HOA governance is complex, that mistakes happen. Then Jessica put Emma on the stand. We'd debated this for weeks. Emma didn't have to testify. We had enough evidence without her. But Emma wanted to. She hurt me, Emma had said when we discussed it. And she didn't say sorry. She needs to hear what she did. So Emma sat in the witness chair, small and brave, and told the jury what happened. I was riding to my mom's bench. I go there every day to talk to her. Emma's voice was quiet but clear. Ms. Vance's car pulled up, and she got out yelling that I was breaking rules. I tried to explain, but she grabbed my bike and pulled really hard. I fell, and my hands hit the ground, and it hurt a lot. What did Ms. Vance do after you fell? Jessica asked gently. She said if I ever came back to the trails, she'd have me arrested. Then she got in her car and left. Did she check if you were hurt? No. Did she apologize? No. How do you feel about riding your bike now? Emma looked down at her hands. I'm scared. I still ride to Mom's bench, but I'm always scared someone will stop me again. There wasn't a dry eye in the jury box. The defense didn't cross-examine. What could they ask an 11-year-old who'd been assaulted by an adult? Closing arguments took most of a day. Jessica was brilliant, methodical, passionate, devastating. Carolyn Vance didn't make a mistake, she told the jury. She didn't misunderstand the law. She knew exactly what she was doing. She knew the trails were public property. She knew she had no authority to restrict access. She knew she was collecting illegal fees. And when a child dared to use the trails anyway, Ms. Vance physically assaulted her. She paused, let that sink in. This case is about power and accountability. Ms. Vance had power the community gave her to manage their HOA. She abused that power systematically for years. She lied, she stole, she hurt a child, and she did all of it believing she'd never face consequences because HOA boards aren't accountable to anyone. Jessica gestured to the evidence spread across multiple tables. But they are accountable to the law, to basic human decency, to the families whose lives they're supposed to improve, not destroy. Your verdict will send a message far beyond this courtroom. It will tell every HOA board member in Georgia that their power has limits, that lies have consequences, that hurting children to enforce fake rules is not acceptable. She looked at the jury. Give Emma Brennan justice. Give her family compensation for what they've endured. And send Carolyn Vance a message she can't ignore. Your dictatorship is over. The jury was out for 3 hours. Verdict: liable on all counts. Damages: $148,000 compensatory. Punitive damages: $500,000. Total judgment: $648,000. The courtroom was packed for the judgment hearing. News cameras lined the hallway outside. Karen Walsh from Channel 7 and at least 4 other stations. The story had grown beyond our neighborhood, beyond Georgia. HOA reform advocates were using our case as an example. Legal blogs were analyzing the verdict. Other families dealing with abusive boards were reaching out. Judge Morrison took the bench promptly at 2 p.m. Are both parties present? Yes, Your Honor, Jessica said. Robert Klein stood. Yes, Your Honor. Carolyn sat at the defense table looking diminished. The navy blazer was gone, replaced by a simple gray sweater. No more clipboard, no more white SUV authority. The jury has returned a verdict finding Ms. Vance liable for battery, fraud, intentional infliction of emotional distress, and civil rights violations, Judge Morrison said. Total damages awarded, $648,000. Additionally, the court notes that criminal proceedings have resulted in a conviction for simple battery. She looked directly at Carolyn. Ms. Vance, the evidence in this case paints a troubling picture. You were given authority to manage a homeowners association, a position of trust. Instead of serving your community, you exploited it. You invented rules, collected illegal fees, silenced dissent, and ultimately assaulted a child. Your Honor, if I may, Klein started. You may not. Judge Morrison's voice was sharp. Ms. Vance has shown no remorse throughout these proceedings. She refused a reasonable plea deal in criminal court. She rejected multiple settlement offers in civil court. She forced an 11-year-old child to testify about being assaulted. The judge shuffled. Papers. The jury's verdict stands. Ms. Vance, you are ordered to pay David Brennan $648,000 plus court costs and attorney fees. You are permanently enjoined from serving on any HOA board in Georgia. And you are ordered to cooperate with the county's ongoing investigation into embezzlement charges. Additionally, I'm ordering the Ridgewater Hills HOA to implement immediate governance reforms. All board decisions must be properly voted on, with minutes published within 48 hours. All financial records must be audited quarterly by an independent CPA. And the HOA must conduct annual training for board members on property law and fiduciary responsibilities. She looked at Miguel, who'd been sitting in the gallery. Mr. Santos, as interim president, you'll be responsible for implementing these reforms. Understood? Miguel stood. Yes, Your Honor. Good. This case should never have happened. An HOA board is not a dictatorship. Members are not subjects. And power, no matter how small, must be exercised with integrity and accountability. Judge Morrison brought her gavel down. We're adjourned. The courtroom erupted. News reporters rushed toward us. Jessica guided me and Emma toward a side exit, while Miguel ran interference. Karen Walsh caught us in the hallway. Mr. Brennan, can you comment on the verdict? I looked at Emma. She nodded. Justice took a while, I said, but it came. My daughter can ride her bike again without fear. Our neighborhood is free from a board member who thought rules were weapons. And hopefully, other HOAs will learn from this case that abuse of power has consequences. What's next for your family? I put my arm around Emma. We're going to ride our bikes to my wife's memorial bench. We're going to tell her that we kept our promise. We protected Emma's happiness. And we're going to move forward. Outside the courthouse, Miguel caught up with us. David, I want you to know, the HOA is dropping all your fines. We're refunding everyone who paid trail fees. And we're replacing the entire board. Fresh start. That's good. It's because of you, because you didn't let her get away with it. Miguel's voice thickened. My daughter Teresa is so proud that Emma's dad fought back. She's been telling everyone at school that bullies can be beaten if you stand up to them. Emma smiled, the first real smile I'd seen from her in months. Can Teresa come bike riding with me tomorrow? She asked. I think she'd love that, Miguel said. That evening, the Ridgewater Hills community Facebook page exploded. Dozens of posts thanking me for exposing Carolyn's corruption. Families sharing their own stories of arbitrary fines and invented violations they had paid without questioning. Someone created a spreadsheet documenting every questionable decision Carolyn had made over 8 years. The list was staggering. Hundreds of violations issued, fines collected, threats made. One post stood out. From a woman named Jennifer Kim, who'd moved out of the neighborhood 2 years ago. Carolyn Vance destroyed my family's joy in our first home. She fined us relentlessly for minor issues: lawn height, mailbox color, trash can placement. When my husband pushed back, she targeted us harder. We eventually sold and left. I'm crying reading about David Brennan's case because someone finally stopped her. Thank you for having the courage we didn't have. The post had 247 comments. Stories like Jennifer's from families who'd moved away rather than fight. Families who'd stayed but lived in fear. Families who'd paid thousands in fines they couldn't afford. Carolyn Vance hadn't just hurt Emma. She'd poisoned an entire community. But that community was healing now. Miguel scheduled an open forum for Saturday. Over 200 residents showed up. They voted to completely rewrite the CC&Rs with input from a property attorney who specialized in HOA governance. They voted to implement term limits for board members. No one could serve more than 4 years total. They voted to require supermajority approval for any fines over $100. And they voted to rename the trail system. The Sarah Brennan Memorial Trail, Miguel proposed, in honor of the woman whose memory inspired her family to stand up for what's right. The vote was unanimous. Emma cried, happy tears this time. Mom would love that, she whispered. 3 months later, the county installed new signs at every trail entrance. Bronze plaques with maps and rules, and at the bottom, the Sarah Brennan Memorial Trail, find joy in the journey. Emma and I stood at the main trailhead, looking at the plaque. I'd brought flowers, Sarah's favorites, yellow roses, and Emma laid them at the base of the sign. Do you think Mom knows we won? Emma asked. I think she's proud of us, I said. We kept the promise. We protected your happiness. I'm not scared anymore. Emma looked up at me. When Carolyn grabbed my bike, I thought powerful people could just hurt you and nobody would care. But you proved they can't. You proved that bullies lose if you stand up to them. We rode our bikes the full trail loop that day, past the duck pond, past families playing in the playground the HOA had finally renovated properly, past neighbors who waved and smiled and called out thanks. At Sarah's memorial bench, Emma stopped and sat down. I sat beside her. Mom, Dad won, Emma said to the plaque. He stopped the mean lady, and now everyone can use the trails without being scared. Dad did good. I put my arm around my daughter, 11 years old and braver than I'd ever been. You did good too, I told her. You testified. You told the truth even though it was scary. Because someone had to. Emma leaned against me. And because you taught me that the truth matters. The legal aftermath continued for months. Carolyn filed for bankruptcy trying to avoid paying the $648,000 judgment. The court denied it. You can't discharge punitive damages awarded for willful misconduct. Her house went up for sale. Her retirement accounts were garnished. The DA filed criminal embezzlement charges based on the fake consulting company and fraudulent invoices. Those charges were still pending when I finished writing this. Miguel and the new HOA board implemented every reform Judge Morrison ordered and more. They hired a property management company to handle day-to-day operations, so board members couldn't accumulate unchecked power. They published monthly financial reports. They held quarterly town halls where any resident could speak. Ridgewater Hills became what HOAs are supposed to be, a community organization that maintains common areas and helps neighbors, not a miniature authoritarian regime. Other neighborhoods contacted Miguel, asking how they had reformed their governance. The case spawned 3 Georgia state bills aimed at HOA oversight and resident protections. None passed yet, but the conversation was happening. As for Emma and me, we healed. Emma's nightmares stopped. Her anxiety decreased. She started smiling more, laughing more, being 11 again instead of being afraid. She joined the school bike club, made new friends, brought them all to ride the Sarah Brennan Memorial Trail. And every day after school, she stopped at her mother's bench to talk about her day. I listened from a respectful distance, giving her space to commune with the mother she'd lost and the peace she'd fought so hard to reclaim. Sarah had asked me to keep Emma happy, to keep her life normal. We'd lost normal when cancer took Sarah. We'd lost happy when Carolyn Vance decided a child on a bicycle was a threat to property values. But we'd fought back, and we'd won. I'm a land surveyor. I measure property lines, determine boundaries, verify what belongs to whom. It's precise work, technical, based on documents and laws and incontrovertible facts. I never expected those skills would be needed to fight an HOA board president who thought she was above the law. But that's the thing about bullies. They rely on people not checking their claims, not questioning their authority, not fighting back because fighting is exhausting and scary and uncertain. Carolyn Vance counted on me being too tired, too grieving, too overwhelmed with single parenthood to challenge her. She was wrong, and when I pulled those county records and found that easement dedication, when I proved she'd been lying for years, when I held her accountable for hurting my daughter, that wasn't just about Emma and me. It was about every family she'd terrorized, every resident who'd paid illegal fines, every person who'd been made to feel powerless in their own neighborhood. It was about proving that no one, not even an HOA board president with 8 years of unchecked authority, is above accountability. The system worked, slowly, expensively, with more stress and heartbreak than anyone should have to endure. But it worked. Emma is thriving now, riding her bike freely, healing from grief, growing into the strong, brave young woman her mother dreamed she'd become. And every time I see those bronze plaques on the Sarah Brennan Memorial Trail, I remember what matters. Not property values, not power, not maintaining control, family, truth, justice, and keeping promises to the people we love. If you want more stories of homeowners standing up to HOA tyranny, hit subscribe right now. Share your story in the comments. Tell me about your own battles with overreaching boards or neighborhood bullies. Let me know where you're watching from and whether you've ever had to fight for what's right even when it seemed impossible. Because these stories matter. They remind us that ordinary people can defeat corrupt power. They show us that speaking truth to authority isn't just possible, it's necessary. And they prove that sometimes the best way to honor those we've lost is to fight like hell to protect those who remain. Sarah, we kept our promise. Emma is happy, Emma is safe, Emma is free, and that's all you ever asked for.